So at Leigh Hilton PLC, we've helped over 6,000 families protect the assets that they leave to their loved ones from divorce, creditors, and lawsuits. We've also helped over 300 families implement the plans that we've designed. And the reason why that's significant to you is for most people, when you put together an estate plan, it's kind of a depressing thing to do. So what you're going to want to do is put together the plan, put it on the shelf, and forget about it. But what's important to you is that you're taken care of if something happens, and your family is taken care of if something happens. And the fact that we've helped families actually walk through making sure the plans work properly on the back end gives you the peace of mind that we're going to be able to do that for you and your family. One of the things that's unique about our firm is we do both estate planning and elder law. So estate planning is who gets your stuff when you die. It's also living trust, which is one of the things we're going to talk through today. Elder law is Medicaid and veterans benefit planning. And if you're interested in that, we've got other seminars online and webinars that you can watch regarding that topic. Our firm also belongs to a lot of professional organizations, so you're getting the experience of not only the attorneys in our firm, but also other attorneys nationwide to make sure that your documents work when they're needed. So at our firm, we have a location in Bartonville, a location in Aubrey, and a location in Denton. It's me and 3 other attorneys, and then we have 10 team members that help to get things done. I've got 2 books if you're interested in them. One is Who Gets Your Stuff When You Die. The other 2 are entitled You're Not Alone. One is Living with Alzheimer's Disease. The other is Living as an Alzheimer's Caregiver. So what is a living trust? It's a legal document similar to a will. They both specify who gets your stuff when you die, but the distinction is what happens when something happens to you. So if you have a will in place and you pass away, that will has to go through a court process called probate. And if the will is written properly, so it's been written by an attorney, it's drafted properly, it takes 2 or 3 months and costs $4,000 to $6,000 for it to go through probate. If you've drafted it yourself online or come up with a homemade will, or for some reason it's not drafted properly, in Texas it's something called a dependent administration and can take over a year to probate a will. With a trust, if you were to pass away, whoever you name next is in charge right away. There's no reason why they have to go through any sort of court process to get things moving. And if you were to become incompetent, they can also step in and take care of things without court involvement. So after you create a trust, a second step occurs. You actually take your assets and you put them into the trust. You are the beneficiary and you're also the trustee, which means the manager. You're in charge of the assets. You can do anything you need or want to with them, and it's put together for your benefit. So you're not giving up control. So during your lifetime, it's business as usual. You stay in control. It's amendable, revocable, changeable. You can make any changes you want to during your lifetime. So one of the reasons why a living trust is better than a will or joint tenancy is it avoids that probate that we just talked about. So it avoids the need for going through court. It also makes sure that the property goes to the right people. So it goes to the people you want it to, and it goes in the way you want it to. You can defer distributions until you feel it's appropriate. So if you have people you're leaving money to who are not responsible with money, you can actually specify as to when they get it and make sure that they don't blow the money. And with a trust, you may avoid court involvement, and the reason why I use the word may is because if it's not funded, if you don't put your assets into the name of the trust, then you're not going to avoid that court involvement. And it may reduce or eliminate estate taxes. And if you're married, there's some planning we can do to actually increase that exemption. It also may protect a single person's assets from claims of future spouses or their beneficiaries. So we can make it clear that it was your property prior to marriage, which allows a lot of protection related to those assets. The only time we recommend joint tenancy, which is where you own property in common with somebody else, is when we know with almost absolute certainty what order people are going to pass away in. So occasionally we'll do joint tenancy if somebody has a terminal illness and they don't have very much in assets. We might want to make it where the assets go directly to the people they want it to. But one of the downsides to having joint tenancy is you have the vulnerability if the person you're joint tenants with gets sued, those assets are vulnerable. So the trust is clearly the best vehicle for most people, keeps the assets protected in the best way that you can. But unfortunately, all living trusts aren't the same. So occasionally I'll have somebody come to one of my seminars, they'll hear about how much easier life is for your family if something happens and you have a living trust in place. And so then they'll decide, okay, all we got to do is find the cheapest living trust out there. But a living trust isn't like a bag of sugar. So if we were to go to the store and we need a bag of sugar, we're going to pick the cheapest one off the shelf. And most of them are priced close to the same price. But a living trust, we really need to look at the quality of what you're putting together. And one of the hardest things for people to do is to judge the quality of a living trust based on the appearance. So there's a company that actually sells trusts door to door. They really are an investment firm. So what they're going to be doing is actually selling you investments. They will actually sell you a trust. You never meet with the attorney. The attorney prepares the document. The investment advisor comes by the house, gets you to sign it, and then that gets put together. Now, it gets put in a really fancy looking binder. So in looking at it, you go, wow, this looks like it's really official, really going to do a good job for my family. But because you haven't met with the attorney, the document isn't actually customized to your family, it's not going to work that well for your family. The other bad thing with these trusts is a lot of times people don't take the time to put their assets in it. And in order to actually avoid probate, we've got to have assets in the name of the trust. Now, I can tell you with almost 100% certainty, if you have a trust that's under 10 pages long, it doesn't cover everything it needs to cover. So a lot of the what ifs and the protections you'd want from your family are not in there if it's a really, really short trust. But there are longer trusts that aren't drafted properly that still cause problems. So in thinking about whether all trusts are the same, are all cars the same? They're only a different price? Are they built the same and maintained the same? Now the red car in this graphic is actually something called a Yugo. And a Yugo was a horrible car to have. So are you leaving your family a Yugo? Or are you leaving them a Lincoln Continental or a VW Bug? What kind of car are you doing? So if we were to go to buy a car, we wouldn't just go out and say, I just want the cheapest car possible. I want a good quality car that'll take care of me and take care of my family. So you might be thinking, what can go wrong with a trust? And I'm going to walk you through a few things that can go wrong if it's not drafted properly. Will it work properly if you're ill or disabled? And it's really hard for people to think about this. So I'm already asking you to think about the depressing topic of if you die, how do you want your family protected and how do you want your assets to go? But a harder topic for us to think through is what if you don't pass away? What if you become ill or disabled, unable to manage your own affairs? Who do you have named to take over? Will they be able to step in and take care of things? And can they step in immediately, or are they going to have to go to court? So one of the advantages to a trust is it allows them to step in immediately. But occasionally there'll be an attorney that will draft a trust improperly, and it'll have language in there that requires them to go to court. Now, one of the local attorneys in our area who recently retired, he used to put in his trust that a judge in his non-judicial capacity could declare you as incompetent. Now, no judge is going to do that, because when a judge is sitting on the bench, he is immune from being sued. But in the event he actually does something outside of being a judge, he's liable, personally liable for anything that goes wrong. So what pretty much that attorney's trusts have put in there as language means that those families are going to have to go to court to take over these trusts and to be able to get charge of the assets. Other thing that's important to think through is HIPAA, the new privacy law. Because if your family can't get access to your medical records, how are they going to know that they need to step in? How are they going to know that they need to take over? And one of the things we do for our clients, because there isn't a standard form for HIPAA, is we actually prepare a release that says, these people can look at my medical records and whatever the doctor wants signed can be signed. And can you easily come back in if you're well again? So one of the attorneys that I'm friends with up north actually had a client who was in a coma for a period of time. Her son took over as trustee. She got out of the hospital, was doing better, and when she went to her son to try to take back over, her son said, "Mom, I really like being in charge, and I'm concerned that you're going to spend my inheritance." And that particular trust didn't have language that allowed the mother to take back over her own trust. So because of that, our trusts actually have language that says if you ever become competent again, you can take back over and be in charge of your assets. So I'm going to walk you through just really briefly about what guardianship is and what probate is. So guardianship is in the event you become incompetent. It's a court proceeding where the court appoints somebody else to be in charge of you medically and financially. And they're two separate decisions. So there might be somebody who's allowed to make your medical decisions and your housing decisions, and a different person that's allowed to be in charge of your money. In this proceeding, the court actually appoints somebody to defend you against it. So in the event that person comes and talks to you, and you say, "I don't believe there should be a guardianship," even if that attorney thinks that you need help with your finances, they're going to have to fight against the guardianship. So pretty much in any guardianship, there are at least two attorneys involved. There's the one that the person who wants to try to get guardianship who's hired, and there's one to defend the person you're trying to get guardianship over. So you have the expense of that, and then also the publicity related to assets and medical conditions and an inability to make good decisions. If we have a trust in place and the assets in the trust, there's no need to get guardianship over those assets. Probate is the process to prove up a will after somebody dies. And with probate, the assets in the will don't actually get transferred to the people they're supposed to go to until that court process happens. Now, I told you a little bit earlier, if the will is done properly, it takes 2 to 3 months, costs $4,000 to $6,000. If it's done improperly, it can take over a year. So will your living trust really avoid this guardianship and probate? And one of the most important things to think through is, have you put your assets in the name of the trust? One of the things we do in our firm is we meet with our clients every 3 years to make sure they've got all their assets in the name of the trust and things are up to date regarding their family. And one of the most common things I have people tell me is the 3-year review meeting reminds them to make sure that their assets are in there. So powers of attorney, they used to not be mandatory for banks to take, but they passed a statute recently that requires banks to take powers of attorney with a lot of exceptions. And in fact, there are so many exceptions that it's really hard even now to get a bank to have to take a power of attorney. So a lot of times they aren't honored. Now the advantage to a trust is you put your assets in the name of the trust, you give the bank a copy of that trust, and you say who you want to have be in charge next. And so they know, the bank knows, that you really did sign the trust because you've given it to them during a period of time and you're still able to make decisions. Power of attorney is usually not given to the bank until you've already become incompetent, and the bank may be nervous that the person presenting it hasn't really been appointed, or maybe you weren't competent when you signed it. So your living a trust may not avoid probate or guardianship, and it's similar to a car. You've got to put gas in the car to make it work. So did you get everything you own in the name of the trust? Did you miss something? So occasionally we have to do a probate for one of our clients because they left an asset out of the trust. Those door-to-door salesmen that I told you about with the thick, really fancy binders, they actually tell people, "Oh, don't worry about putting assets in the trust. We can just go through probate when you pass away." Well, one of the main purposes to doing a trust is not having to go through probate. A lot of times in the 3-year review meeting, people will say, "Oh yeah, between the time I signed and this 3-year review, I bought something new and I forgot to put it in the name of the trust." A pour-over will or a trust schedule isn't enough to put the assets in the name of the trust. So if we just use the pour-over will to put the assets in the trust, then what happens is we're having to go through probate. And then occasionally we'll run into somebody who will, like the trust people that sell those trust binders, will actually say, "Oh, just list all your assets on the back." If you don't actually go to your investment firm and change the name on the account to the name of the trust, it's not going to end up being in the trust if something happens to you. Also, we want to make sure that we protect your loved ones from losing what you give them from unwanted third parties or the government. So outright distributions, if you were actually to give money to people outright, It may be wrong if your beneficiaries are too young. So if we gave an 18-year-old $100,000, what are they going to do with it? And the answer to that is always spend it. It's just a matter of what they're going to spend it on. If you don't specify, you're putting an 18-year-old in charge of their own money. If they're elderly, ill, or disabled, if they have drug or alcohol problems. Now, I have a client who actually had a grandson who was left money by the other set of grandparents, and the grandson at the time he inherited the money was a recovering drug addict. He had actually been clean and sober for 20 years at the time he inherited. He inherited the money. During the period of time he was addicted to drugs, he didn't have a lot of money of his own. And so he couldn't buy what he considered the fancier or the more expensive drugs. And so what he did with the inheritance is he said, I'm going to spend one weekend, I'm going to take those drugs, and then I'm going to go back to being clean and sober. And his logic was, because he had been clean and sober for 20 years, he felt like he was strong enough that he could resist the addiction problem. So he did buy the expensive drugs, did overdose during that weekend, and killed himself. Now, I told the story at a seminar a while after that, and somebody said, I've got an even worse story. And I said, what was the story? And they said, well, my grandson inherited the money, did the 1 weekend of drugs, became addicted again, and is living that life. So if you have somebody who's recovered from drug addiction or is currently addicted to drugs, we might talk about whether we want to put some parameters or restrictions on how they get the money. If they're not good at handling money, and you've always got to look at not good at handling the amount of money you're going to give them. Because there's a lot of people that are really good at handling the money they have, but if they had a larger amount, they wouldn't be. I have a couple I represent that I would have held out to you as a couple who could handle inheriting $1 million without blowing it within a year. They were actually hardworking, very practical people, and very frugal with their money. And her mother passed away, and she inherited $800,000. And a year later, they were actually more broke than they were prior to inheriting the $800,000. Now, you may wonder, how do you become more broke after you have $800,000? Well, they did what a lot of lottery winners do, which is they had the $800,000. They figured it was more money than they needed for the rest of their lives, so they both quit their jobs. And then they set about spending the $800,000. So a year later, they're both unemployed, and they've spent all the money that was inherited. So you've got to be careful about, are they going to be responsible enough to handle what they've inherited? If they're receiving government benefits that are needs-based, they're not allowed to have more than $2,000 in their name. So if you leave them more than $2,000, you're actually throwing them off of the government benefits. And there are people out there that can only get health insurance because they're on Medicaid, especially people who have a disability that they've had from childhood. And so if you leave a grandchild with a disability that's on needs-based benefits, $10,000, you're actually throwing them off of the needs-based benefits, and a good portion of the physical and occupational therapy that they have or group housing has waiting lists. So it may be a matter of that they can't get that service again until the money is fully spent. And even if we've got these things covered, what if this situation changes after they're gone? So part of the reason why the trusts we draft are very long is we try to cover all the what ifs in life. So what if one of your beneficiaries becomes disabled between now and when you pass away? Or what if they become disabled after you're gone? Is there language in there that protects? And one of the things that we put in all our trusts is a role called a trust protector. And what it does is it allows the person you've named as trustee to amend your trust for typographical errors, for law changes, or major changes in the beneficiary's circumstances. It allows that change to be made without any court involvement. Nobody has to go to court to have the change made, but it can adjust for these changes in the circumstances. So let's assume none of those problems exist. There's nothing that you're worried about related to the beneficiaries. Outright distributions may still be wrong, because you want to make sure that the money's protected if the people you're leaving money to ever get divorced, or if they have creditor or bankruptcy problems, or if a fortune hunter's lawsuit tries to take it. So one of the easiest ways to settle a lawsuit is to show that there's not anything out there for them to get to. And if the trust is done properly, the amount that they've inherited from you is not vulnerable to that lawsuit. The government can force it be spent or paid over to them if they're on government benefits. And even if none of those happens, it can be exposed to a second estate tax. Now, with the estate tax right now, the government has pretty much lulled us to sleep. So the exemption is high enough that most people don't have enough money to have to worry about estate tax. But I believe that in our lifetime, the exemption is going to come back down. And if not our lifetime, definitely our children's lifetime. And so if the exemption comes back down, anything over the number the government sets, the government takes 50% of. So when I first started practicing, the exemption amount was $600,000. I had a lady who inherited from her father a $3 million IRA. And because it was over at that time, the exemption was $1 million. And so the government actually took $1 million of that $3 million in estate tax. Then because retirement money is not taxed with the time it's put in, it's taxed at the time it comes out, she actually had to pay income tax on the money. So income tax on the entire $3 million, ended up taking about another $1 million of the money. And then the government also, she pulled it out faster than they wanted her to. And there was a penalty during that period of time, a 15% excise tax, for pulling too much out of a retirement account in 1 year. And some of these somewhat offset each other. But what ended up happening, of the $3 million IRA that she inherited, she ended up getting to keep about $800,000 because of the tax consequences. So if we do the planning properly, we can actually avoid the estate tax when you pass away. We can also avoid the estate tax when your kids are leaving the money you left to them down to the grandkids. So let me walk you through a case study. The client's name is Bob and Betty. They have 3 kids. Their oldest son, Bob Jr., has a high-maintenance spouse. They're a little concerned that she might want to spend the money. He's also in a business where he's likely to get sued. So he's a surgeon. He's worried that he might get sued. And there might be a second estate tax, meaning he might be successful enough that when the money goes to the grandkids, there might be an estate tax. If we give it to him outright with no protections on it, it's vulnerable to all 3 of these. Middle daughter is Jane. Jane lacks the financial experience to manage the money. She's actually good with the money she has. The parents are just concerned that if she had a larger amount, that she might not do what she needs to with it. And she's got a problem marriage. And actually, Jane doesn't think she has a problem with her marriage. It's more her parents don't like the son-in-law. And so they want to protect against him taking it. And if we don't put protection around it, and in a minute I'm going to talk to you about protection that we can put on there, when Jane passes away, she's going to leave everything to her husband. And if he remarries, he'll leave it all to whoever he remarries next, disinheriting the grandkids. So in a minute I'm going to talk to you about a protection that makes it where it's clear it stays hers and then it goes down to the grandkids. And then this family has a Jim. So the Jim's the youngest son. He's had some creditor problems. He's filed for bankruptcy a few times. He's trying to qualify for disability, and he's also got lots of lawsuits against him. Now, most families have somebody like Jim who's not quite getting it right. Now, actually, I probably ought to change this slide to being 4 kids. Because I have some clients who have somebody who's just irresponsible that they're worried about protecting against making bad decisions. And then I have some that are just soft-hearted and vulnerable. So one of my clients, their daughter, she's a missionary. She doesn't make enough being a missionary to really support herself. So they actually send her $10,000 to $20,000 a year every year. And their concern is if they leave her $200,000, she's going to look at the situation of the people she's helping and realize that and feel like they need the money more than she does. And so she's very likely, if they leave her the $200,000 outright, to give it away without thinking through the fact that it would be nice to have the $10,000 to $20,000 a year so she can continue to afford to be a missionary. So they're actually putting somebody else in charge to protect her from her soft-heartedness and desire to give things away. So living trust, we recommend what we call a heritage trust on all 3 of these. So heritage trust is where we can either allow the beneficiary to be in charge themselves but protect it from the outside world, or we can protect the beneficiary from themselves. So with Bob Jr., we would set up a heritage trust. We would let him be in charge of his own trust, but we could put in language that protects the money if he were to get divorced or sued, and then also from that second estate tax. For Jane, we can actually put in professional money management, and we can actually do this for all 3 kids. I don't know if you've seen the commercial, but there's a commercial out there for financial advisors, and it's a really nicely dressed man who's meeting with this couple and telling them how he's going to help them with their finances. And at the end of the commercial, they actually agree to hire him. And he says, no, wait a minute, I want to let you know something very important. He said, I'm an actor. I know nothing about investments. But they've chosen him based on the fact that he says the right words. And pretty much the commercial is about the fact that you should look for credentials in the financial advisor to make sure they know what they're doing. So is Jane going to know how to pick a financial advisor, or is she just going to pick one of her neighbors that seems nice? So we can put language in that says she has to use the financial advisor you're currently using, at least for a period of time, or gives her criteria on how she would choose one. We can also put language in there that protects the money in case she gets divorced, also keeps her from leaving it to her husband. And then what I'll have happen with a lot of my clients when we get to Jim and we're trying to decide what to do with his money is they'll say, I put Bob in charge of his own money, I put Jane in charge of her own money, so I have to put Jim in charge of his own money because that's fair. But if you think about it, Jim needs more protection than that. And you've probably worked really hard at protecting him for most of his life. So doesn't it make sense to put language in the plan that protects him? And then the other question is, are we going to put Bob Jr. in charge of it? So if Bob and Jim get along at all, are they going to get along if you put Bob in charge of Jim's money? And the odds on that are pretty low because Jim is constantly going to be asking Bob for money. Bob's constantly going to be telling him no. What is that going to do for their relationship? And one of the things that I've found that most of us have in common is we want our kids to get along. And even if they can't stand each other, we have this fantasy that one day they're going to get along. So outright distributions, I don't recommend them even when the beneficiary is responsible because I want to make sure that they're protected against the outside world. Also, a few special issues for people who are single. So if you're single, you really need to think through who do you trust to manage your money if you become disabled. If you're living with somebody, you need to think through, do you want them to be able to stay in the house if something happens to you? What do you want them to inherit? What parameters do you want to put around that? So also, I want to talk to you very briefly about your potentially largest asset, your retirement plans. Those are left unprotected by a living trust. And retirement plans are actually most likely the largest asset you're going to leave behind. Because most of my clients are being required to take out distributions from their retirement accounts, complain about having to take it out and pay tax on it. So most of us are going to spend that money absolutely last. And there's some protections we can put on it if we put it inside of a retirement plan trust against that divorce, creditors, and lawsuits. Now, I have a different seminar that you can watch that goes into detail regarding retirement plan trusts. Also talks a little bit about the new Secure Act that was passed last year. So under the IRS rules, they allow longer stretch out for you and your spouse. They've raised the age that you need to take distributions to 72. And a significantly longer stretch out for non-spouse beneficiaries. Some beneficiaries, it's a 10-year payout under the Secure Act. Some, it's actually over their lifetime. So basically, retirement plans, you have 3 choices. You can name individuals directly. They might take it out slowly, but you're not going to have the protection against the divorce, creditors, and lawsuits. You could give it to your living trust, but that makes a 5-year payout, so you lose that 10-year or lifetime depending on the beneficiary's status. And we could add protection language to that trust. The separate retirement plan trust can allow both the stretch out and the protection. Now, under the Secure Act, even though a retirement account has to come out in 10 years, that doesn't necessarily mean all the money has to go out to the beneficiary. So a retirement plan trust is a living trust designed specifically for retirement plans, and you should consider it if you and your spouse have IRAs or other retirement plans totaling over $200,000, or if you have beneficiaries that need protection. So if you have people you're leaving money to who are under the age of 18, it's definitely worth putting a trust wrapper on it to protect it. So even if we get the best living trust possible, are the people that take over going to drive it properly? Are they going to know what to do? And will it properly be serviced? So one of the things I do is a seminar specifically on what the responsibilities of the trustee are, so they know how to properly drive the trust. We also, for the service, we meet with you every 3 years to make sure that the trust does what you want it to do. So with it, do you get an owner's manual that tells you what your responsibilities are? We do a one-page flowchart summary of the trust, so it lets you know how things go, how things get put together, so that you're able to understand that in a one-page summary. We also give you transfer letters and an ID card, so that it helps you get your assets into the name of the trust. Checklist of actions, things that are important to get done. Personal direction letter allows you to give instructions to the kids regarding where personal property goes, how you want that divided. And then also very important is a location list, so the kids will know what assets you have, where they are, how to locate them. I also have created a trustee manual, and the reason why I put this together is back when I was in my 40s, I was giving a speech, and I had a lady who was in her late 90s, really bad health, ask me, after I said we'll help walk your kids through how you're going to put together your plan, how it's going to be protected, she said, well, honey, what if you don't outlive me? And it's interesting because you know at the end of the football game where they pour the water over the coach? That's how that felt in that moment. Because I couldn't imagine a scenario where I wasn't going to outlive her. But if I don't outlive you, the manual actually gives your kids instructions on how things are going to be put together. Now in our firm, the 3 other attorneys that are in our firm are younger than me. And so hopefully if things happen the way they should outlive me. And they'll be around to walk your family through what they need to do. But the manual will also walk them through. Because most people who start taking over as a trustee have never been in charge before, don't understand what their responsibilities are. We also give you the ongoing service. So included in our fixed prices is phone calls to answer your questions. We'll answer emails. We meet with you every 3 years, make sure your plan does what you want it to do. Also, we do frequent seminars, and I have lots of clients that will come to seminars just as a refresher course on how things are put together. Occasionally, we'll think through things they want to change. So which would you rather have your loved ones drive? The Yugo or a fancier car that makes sure that your family is taken care of? Are you willing to gamble away your loved one's future? Now, where do we go from here? Most of you are going to end up procrastinating because one of the hard things is we're not planning on dying. So we've just got to get this done between now and when you pass away. Earlier you put it together, the easier it is for your family, the easier it is for people to step in if they need to. If you'll contact our office, we can schedule a free consultation where we can kind of walk through, get to know your family, and then design a plan based on your individual family situation. We look forward to seeing you.